Hello and welcome to Sunya IAS. Today we'll be continuing with our next chapter, that is chapter on judicial review. Okay, this chapter is also important. Judicial review, judicial activism, judicial overreach. Okay, these are the 3 to 4 concepts जिसके एक बार definition you must read, because the thing is कि people, some new people, those who are like very new first years, though they think that all these concepts are similar but these concepts are different. Judicial review वो होता है कि judiciary is reviewing parliament's law. ठीक है. Judicial activism is something that judiciary is acting proactively. There उनका area नहीं है, उस area में भी they are working. It means that they are breaching the gap or the line created by separation of power, judiciary, executive और legislature के बीच में. Whenever they are breaching that line, judicial overreach and judicial activism उसी को कहते हैं. Okay, so and PIL, some aspect of PIL which we already saw in the chapter of Supreme Court, that it is a public interest litigation. It is applied, or when we put for the PIL petition, that petition is for larger public interest, not for an individual interest. Okay. Chalo. So let's see from the first question itself. Consider the following pairs. Here there are cases given and what was the judgment in that case is given, and you have to see that how many of them are correct. Now ये सबसे पहले देखना है please. So Olga Trellis case, it is saying it is about the right to slum dwellers. This pair is correct because there was a case when Bombay Municipal Corporation, BMC in Maharashtra, decided that they will evict each and everyone from the sideways of the road and from slum. So case went to Supreme Court and Supreme Court said that every person has right to livelihood, and right to livelihood, Supreme Court in that case kept it into Article 21 और उसको 21 के अंडर ही है. Like that they considered under Article 21 as right to livelihood. ठीक है, right to livelihood. Similar type of question we saw in our fundamental rights chapter. I think second last question, that which rights are there which comes under Article 21, which rights are coming under Article 19. So certain questions were there. In questions the statements were also there, and also at the same time one specific separate question was also given. So kindly go through that judgments also. So this is right to livelihood under Article 21 declared by Olga Trellis case, very famous case of 1981. Again, next case is Subhash Kumar versus State of Bihar case. It is about environmental protection. In this case, yes, this pair is also correct. In this case, it was actually against Tata Steel, Tata Iron and Steel, which used to say that Bokaro River mein you are dumping your slurry. So this eventually at the end of this trial, at the end of this case petition was dismissed, but in this case it was declared that right to enjoy pollution free environment and air. Okay, pollution free environment and air. In this Subhash Kumar case, pollution free water and air. Very famous case. This is also very, all these cases are very famous. अगर आप means की पढ़ाई, if you have already completed, you already know all these cases. ठीक है. So this was again put into under Article 21 of the Indian Constitution. Most interpreted constitution, or you can say the article which came most under the judicial activism or overreach of the overreach in the Indian Constitution is Article 21. सबसे ज़्यादा interpret इसको किया गया, right? So statement can come with respect to that also. So Paschim Bengal Khet Mazdoor Samiti versus a state of West Bengal, right to free trial. Right to free trial, it is saying. Paschim Bengal versus Khet Mazdoor. Actually, what happened was, in this case, there was a person who fell from the train. He fell from the running train and he got injured, and the other people, some agricultural laborer, took him to hospital, and the government hospital denied him treatment. So this statement, this pair is not correct, as it is not with respect to free trial, but it is with respect to मेडिकल केयर, राइट टू मेडिकल केयर, उसको एग्जैक्टली कैसे कहेंगे, राइट टू टाइमली मेडिकल ट्रीटमेंट, टाइमली मेडिकल ट्रीटमेंट, ठीक है। दिस इज नॉट विथ रिस्पेक्ट टू राइट टू फ्री ट्रायल, बट दिस इज विथ रिस्पेक्ट टू राइट टू फ्री timely medical treatment. Okay, so this pair is not correct, pair 3 is not correct. Okay, again this was also put under article 21 of the Indian Constitution in fundamental right part 3 of the Constitution, right to life का part है, उसको कहा गया। L. Chandra Kumar case, judicial review as the basic structure. Yes, this was said by Supreme Court in L. Chandra Kumar case also. Plus, first time it was said by Keshwanand Bharati case. ठीक है, in 1973 in Keshwanand Bharati case, Supreme Court said that judicial review itself is a basic structure of the Constitution, as Parliament has already came up with the 2 constitutional amendment. हमने fundamental rights में इसको discuss किया है। Okay, so yes, Chandra Kumar case में actually the case was related to tribunals, and it was like the previous judgment of Supreme Court said that whatever, like, see, to the aim for bringing the article 323A was that to reduce the burden on judiciary. It was on tribunals. So what tribunals will do, it will deal with the cases related to specific departments. जैसे if there is a case related to civil services, it will go into CAT, है ना, Central Administrative Tribunal. So if CAT will give some decision and you will not like that decision, previously it was said that the decision of tribunal is final. But Supreme Court said that in this case, High Court and Supreme Court are constitutional courts, and which cannot be replaced, as judicial review should not be taken, like they only cannot deal with the case. The appeal from that tribunals can come to High Court, and 2 judges bench of High Court will deal with that appeal. ठीक है, so they reiterated the stance that judicial review is a part of basic structure of the Constitution. Okay, so again our answer will be C only 3. Next question. I hope all these cases are like in your brain now. Judicial review basic structure hai, except this 4th statement, this right to timely medical care, environmental protection, this one, free and pollution, free and water and air, clean water and air is our under article 21, and again right to livelihood, again article 21, right to life. ठीक है, याद रखना इसको। Next question. Consider the following statement about judicial review. Judicial review is explicitly stated in Constitution. No, it is not explicit, it is implicit. Why? How it is implicit? It is implicit in article 13. It is implicit in article 32, 226, 136. Out of this, we already saw these 3 articles in fundamental rights, right? But what is there in article 136? We saw in our previous lecture. Special leave petition. ठीक है, that is, if some law is also threatening you, if there is some, with respect to any law you have any complaint, that law is grave, endangering your grave right or something, then you can directly come to Supreme Court special leave petition से भी, but rights के लिए ऊपर का 32 and 226 in High Court, 32 and in Supreme Court you can go, and इससे derived है अगर if this statement was judicial review article 13 of the Indian Constitution, इसमें से कोई भी आर्टिकल provides for, इस स्टेटमेंट, इस वर्ड का मीनिंग समझो, प्रोवाइड्स फॉर जुडिशियल रिव्यू, और इंडियन कॉन्स्टिट्यूशन, द प्रोविजंस ऑफ इंडियन कॉन्स्टिट्यूशन इटसेल्फ प्रोवाइड फॉर बेसिक दिस जुडिशियल रिव्यू। तो तो yes, it provides for, it does not explicitly mention. Implicit का मतलब ही होता है provides for, right? So the statement 1 is not correct. Let's see statement 2. The concept of judicial review was first developed in England. Deliberate statement, incorrect statement. You must know that England have parliamentary sovereignty. We already discussed it yesterday in our previous class on Supreme Court, that Parliament has parliamentary sovereignty, yani ki Parliament has the supreme power to make law. Parliament is both, it has both constituent power also, and they do not have constitution, तो constitutional power नहीं रहेंगे, ठीक है? So their parliament is supreme, parliament is sovereign, their law cannot be interpreted by Supreme Court. I already told you that their Supreme Court was established in year 2005 under Judicial Reform Commission, right? So this statement is also not correct. Where it was developed? It was developed in USA. Again, statement, which of them are correct? Neither of them are correct. D will be your final answer. Let's see next question. Consider the following articles of the Constitution, and in which of the above articles Supreme Court's power to judicial review. ठीक है. Can we trace the Supreme Court power? Trace कह रहा है, it is given नहीं कह रहा है, provides for कह रहा है again. So where you can find the provision of judicial review? We discussed this article number 226, article number 13, है ना? Law inconsistent with fundamental rights shall be declared void, article 13. So High Court's power for writ jurisdiction also, and to deal with the other rights also, article 226. So what is this article 372? It's with respect to pre-constitutional law, and it is it does not mention explicitly, but this laws will be considered valid. That's what it is declared. And now to the extent it will declare valid, वो judiciary ने अपने आप पर ले लिया है, we will review that those laws and will tell that if those laws are with respect to constitution or not. Judicial review, यहाँ पर they derive the power from this article also. Hence your answer will be 1, 2 and 4. अगर 1, 2 भी पता होते तो this was eliminated, this was eliminated, we are on 50-50 option. But 128 अगर पता होता, this was already asked by UPSC CSE, that retired judge, in case of requirement of additional judges in Supreme Court, retired judge can be called for sitting on his consent. He need to give a consent that yes, I will come. Okay. So yes, this article is related to this, and again judiciary में ही आता है article. I have already told you article 124 to article 147 is with respect to judiciary, है ना, part 5 of the constitution. Chalo, that's it. We'll see is our answer. Next question. Which of the following statement is not correct with regard to PIL? Okay. So public interest litigation can be filed in both Supreme Court as well as High Court on behalf of those whose rights were being violated or whose rights were already violated. Yes, the statement is correct. I already told you that personal interest नहीं होना चाहिए, public interest होना चाहिए. At the larger extent the interest should be there. And the doctrine of locus standi, this means that I am myself standing for myself, है ना? I am coming into court, एक general language में बता रहा हूँ, I am putting a case or a appeal in a court that this case is my some of my rights are violated, ऐसा समझो, ठीक है? But locus standi यहाँ पर नहीं है. So on behalf of this person's group of persons you can file a PIL. This statement is correct. Next statement. The first reported case of PIL in India was Husaina Khatun versus State of Bihar in year 1979, chaired like the justice at that time was Justice P.N. Bhagwati. At this time the PIL came to light. Yes, this statement is also correct. Third statement. Procedural laws and rules of locus standi does not apply. I have told you that rules of locus standi does not apply in case of public interest litigation. और procedural laws क्या होते हैं? The normal court के procedures, legal procedures will not apply. That's what it is saying. What does this means? कि उसकी फीस के बारे में, if a general case requires this much of fees, then PIL will require less fees, है ना? या the procedure, whatever procedure to write also, to how the legal format to write a case, that is also waived off at some extent. Yes, this is correct. This is not about parliamentary laws. Okay, this is about the procedure. Next, the midday meal scheme introduced by central government is an outcome of PIL. Obviously, last statement it is remaining. So ये तो incorrect होना ही है. Yes. First of all, midday meal was introduced in 1925. Where? In Tamil Nadu. Government of India in 1995 started implementing midday meal at all India level. In year 2001, Food for All campaign was there. Right to food campaign. Okay. The PIL was filed by this right to food campaign, and the case was called as PUCL versus Union of India. Case 2001. In this, after the judgment of this case, the implementation of midday meal was strengthened, but we cannot say that the existence of midday meal scheme was due to the PIL. Okay? Yes, implementation was strengthened, better, the implementation became better because of this PIL, but not the origin of midday meal scheme. Hence, D will be your answer for question number 4. Let's see next question. Question number 5. Consider the following statement with respect to judicial restraint. This statement, I'll explain it like very easy question actually. Judicial restraint matlab kya hai? See, who can restrain? One animal, you can restrain that animal, like you are a third party for that animal and you're restraining him by putting in chains. You're restraining him from doing something. So what is there in constitution which can restrain judiciary? You only and only constitution itself, the provisions of constitution can restrain judiciary to do something. Now if parliament is adding something to restrain judiciary can outrightly tell that you are going against the freedom of judicial freedom or judicial independence. So there is a problem. So this restraint of judiciary should come, judicial restraint should come from itself. Why? Because if judiciary will not keep this restraint on itself, it will keep entering into the domain of executive and legislature. आपको पता होगा firecrackers ban, again that 500 meters there will be no drinking and wine shops etc. hotels and that things were declared by UPSC. एक executive order था, Vishaka guidelines were given, that was legislative work, that legislature should make some guidelines with respect to any sexual harassment of workplace or etc. things. So this was, judiciary should not enter into their domain. Judiciary either should command these bodies, that executive and legislature, that you should make something with respect to this, and after judiciary will command, these executive body will work automatically. This is how the chain of command should go on, but judiciary itself is taking some initiative and itself implementing and telling these laws. So this means judicial laws are made in India. Law making body abhi 3 ban gaye. Fir executive, legislature has the law making primary function, executive banata hai, delegated function by legislature, and judiciary is also making laws. So this is against constitutional spirit of constitution. But judicial activism के अपने कुछ फायदे भी है, ठीक है? But at the same time, this is against separation of power, judicial activism and judicial overreach. Hence, judiciary must practice judicial restraint. ये है एक proper conclusion for whatever question is there on judicial activism. है ना. ये एक फॉर्मेट होता है क्वेश्चन कंक्लूजन का. इन मेंस यू प्रिपेयर रेडीमेड इंट्रोडक्शन एंड कंक्लूजन सो दैट यू कैन जस्ट कॉपी इट एंड पेस्ट इट देयर. इट विल नॉट वेस्ट योर टाइम. तो एक कुछ थीम्स होते हैं यूपीएससी के. यूपीएससी कीप ऑन आस्किंग द क्वेश्चंस इन मेंस आल्सो ऑन द सेम थीम्स. ठीक है, 5 to 10 क्वेश्चन एवरी ईयर आर देयर ऑफ द सेम सॉर्ट ऑन द सेम थीम. तो 5 to 10 क्वेश्चंस के लिए रेडीमेड इंट्रोडक्शन एंड कंक्लूजन बनाया जा सकता है. आउट ऑफ दैट कंक्लूजन दिस जुडिशियल रिस्ट्रेंट इज वन ऑफ द कीवर्ड. सो it is judicial restraint is against the concept of balance of power. It is not against, rather it is enforcing the concept of balance of power. It violates the independence of judiciary. No, rather it is giving more and more power. Judicial restraint अगर जुडिशियरी नहीं कर रहा है तो इट इज गिविंग मोर एंड मोर पावर टू जुडिशियरी. और जुडिशियल रिस्ट्रेन कर रहा है तो रादर कॉन्फिडेंस ऑफ पीपल इन जुडिशियरी विल इंक्रीज, है ना. पीपल विल थिंक कि जुडिशियरी इतना इसेंशियल है, जुडिशियरी इज द ऑर्गन दैट इज डूइंग समथिंग फॉर अस, है ना. उसका कॉन्फिडेंस पीपल से अगर उठ जाता है तो जुडिशियरी का इंडिपेंडेंस भी खत्म हो जाएगा. सो दिस इज ऑल्सो नॉट करेक्ट. It recognizes the equality of other two branches of judiciary. This means that these other two branches, if it stops or if it starts practicing judicial restraint on itself, it will stop this activity, and this will be considered as separate existence of these bodies, and you have your own separate powers, and separation of power will be established here. Yes, 3 only, that is 1 only is your correct answer, A. I hope you got this. Next question. Kindly read it and solve it. Incorrect पूछा है, ये भी एक बार ध्यान रखना आप. Incorrect पूछा है. It is asking you which of them are incorrect. Which of the following are the positive impacts of judicial activism? सोचो, positive पूछा है again. If in short you will see it is again separation of power, but positive impact क्या हो सकता है? What is judicial activism? Judiciary taking a proactive stand. Proactive का मतलब क्या होता है? There are two things. One is reactive, another is proactive. We have seen this in governance वाला paper. जब भी आप, if you were in lectures, you must have heard that thing कि civil services must be proactive rather than reactive. This means that rather than something, if something is happening and then you are giving response to it, proactively you try to stop that thing. Even in health, while you maintain your health, you can say that you should proactively stop, keep care of yourself, otherwise you will get diabetes and all, है ना. Proactive कहते हैं. फिर diabetes होने के बाद hospital जाना है, then we are taking reactive step. It is better than that is taking proactive step, है ना. तो proactive with respect to judiciary मतलब अगर legislature कुछ कर नहीं रहा है तो ये खुद होके कुछ कर देगा rather than giving them order. Okay, so there are some benefits also. So the idea of rights gets expanded. Yes. So देखो, when I say that Article 21 में ये आता है, was it or is it written in original constitution? No, it's just an interpretation of judiciary कि हाँ वो हम कह रहे हैं वो आता है तो आता है, right? Now if judiciary is saying that it comes under right, but who can put or who can amend the constitution? Parliament can amend. Now who is amending the constitution? Judiciary is amending the constitution. So in spirit, if you will see, the parliament, the constitution का spirit follow नहीं हो रहा है, right? So this is, yes, it expands right. Democratization of judicial system, yes, people can reach at judiciary. More and more people are coming under the judicial, like you can say, if judiciary is giving some decision with activism, so at the same time people के साथ justice is reaching to people. Okay, so yes, democratization of judicial system. Blurred lines of distinction between legislature, executive and judiciary, what we saw here. Same, it recognizes the equality, and iska ulta kya hota hai? It does not recognize this equality. This means whatever lines are there between executive, legislature and judiciary, ये blurred है because judiciary can enter through these gaps in their domain, है ना. तो लाइन ब्लर हो रहे हैं because of judicial activism. Which of them are incorrect? None of them are incorrect. D shall be your answer for question number 6. So let's see next question. Solve it. Which of the following are essential aspect of natural justice? ये चार पढ़ना है and you have to solve it, and here correct is asked. I'll move aside, pause the video and run solve. So what does the statement says? Right to fair hearing, recuse himself. Before knowing this, you must know the three principles of natural justice. Three principles: fairness, reasonableness, and impartiality. Three principles: fairness, reasonableness, and impartiality. ठीक है, three principles. अब इस three principles को उठा के you pick this principles and apply on each one of them. See, right to fair hearing or the ultim partem, ठीक है, that you heard कि that the person in front should also have right to be heard. Right to be heard मतलब he should have a right to give evidences. If you are alleging him something of something, he should be right, he should have right to give some evidences. Or if you are alleging someone else, so you still have right to give evidences against him. At the same time, he also has right to reply you. You must give him, and the court must give him right to speak or right to clear his stance, है ना? Right to he must have right to respond on what you have alleged on him, right? One. Second is, if you are proceeding against him and he don't even know that the case is going on in court, he has the right to be notice, like send notice about the proceedings. He should have that right also. At the same time, if he does not have any one to represent his case, so he has right to representation also. So this means that right to fair hearing is your answer. Second is correct. Judges recuse themselves in case of vested interest. क्या मतलब है इसका? See, U Lalit was one of the Supreme Court judge. He recused himself. Recused यानी कि उन्होंने खुद को केस से हटा दिया. He removed himself from the case. He said that I will not sit as the judge in this case because I have represented one of the party previously in this case. This means that there was a conflict of interest. Whatever judgment he gives, is it rational or not? We don't know, but we will question his rationale, as we'll say he has his interest vested in the party which he represented previously, and that's why he gave this kind of judgment. Can be said. So there is like conflict of interest should not be there. That's what it is. So yes, this also talks about fairness. Okay, so it talks about fairness, but more of a fairness also and impartiality also. Next, judgment given by the court should be well reasoned. There are many Supreme Court judgments in which Supreme Court again and again said that even lower court or high court or Supreme Court, whatever judgments you are given, that judgments should be attached with the reason that why you are giving this particular statement or judgment in your whatever you are telling. So the reason should be there, right? So this is also correct. Judicial review of the laws. Ab 1, 2, 3 correct aa gaya. So this means that only 2 will not be your answer. Judicial review of the laws. What does this mean? Judicial review जो कर रहे हो यहाँ पर कहाँ आ रहा है? Nowhere. Judicial review is something a constitutional provision. It is not with respect to natural justice. Statement 4 is not correct. Again, access to cheap justice. It is about accessibility. They are not comparing someone, like they are not saying cheap justice for poor. They are just saying cheap justice. So fairness bhi nahi aa raha, reasonableness or impartiality is also not covered there. Hence, question statement 5 is also not correct. Your answer will be B, only 3. Right? Question number 8. I hope you got this. Ye 3 principles are important. Apply this on. With reference to the position of judicial review in India, consider the following statement. Kindly read the question, solve the question, pause karke you have to solve. Okay. Judicial review includes the power of judiciary to review its own judgment given in the earlier similar cases. See, this came up from directly the statement, or some sort of statement is coming up from the previous year question. This is reviewing its own judgment. Article 137 IAS. Article 137. और इसी से आया है रिव्यू पिटिशन. We discussed it yesterday, है ना? Review petition is not a constitutional provision like special leave petition. That's what I say. So it does not say that reviewing laws or executive. Judicial review क्या होता है? If you are reviewing legislative law or executive orders, so it is not with respect to that. This statement is not correct. One eliminate कर दिया. What 2 and 3 as your answer? What 2 and 3 as your answer? So 2 and 3 obviously became correct. In India, power of judicial review cannot be excluded even through a constitutional amendment. Yes, it cannot, because we already saw Keshwananda Bharati case 1973, Minerva Mills case 1980, and L. Chandrakumar 2002. These three cases already said that 1997, sorry, 1997, that judicial review is the basic structure, is a basic feature, essential feature of the Indian Constitution. So how you can say that judicial review say ye, that in India power of judicial review cannot be excluded. Yes, it cannot be excluded. Okay? So yes, it cannot be excluded. You cannot exclude it, as it is a basic feature of Indian Constitution. Next, the principle of judicial review is not automatically applied, which means that Supreme Court cannot itself apply the doctrine. इसका मतलब यही है, we have the principle of adversarial legal system. इसका मतलब the meaning of this adversarial legal system is that Supreme Court जाकर किसी केस को they cannot investigate. They cannot investigate. Case must come to them, and then they'll see the legality, then they'll evaluate the case, they'll evaluate the evidences and everything, whatever said, whatever done in the particular situation by that people, that person involved, both parties, and then by the evaluation and the whatever they have been submitted, only on the basis of that they'll take the decision. Not on the basis of what newspaper is saying, that what police found. What police found, what newspaper is saying is not important unless the police has submitted the same evidence or same thing with the judges. Judges cannot rely on anything, whatever is happening outside. They can rely on whatever there is on their table. That is adversarial legal system. So unless the case will not come them, it should be attracted. That's what it is said. So the principle of judicial review is not automatically applied, correct? It means that the Supreme Court cannot apply for itself, by itself, for judicial review. The statement is also correct. Last question. We'll see the last question. Consider the following statement with regard to the exclusion of judicial review. यानी कि which of the above are excluded from judicial review, in which judiciary cannot enter. क्या कह रहा है? The advice tendered by Council of Minister to the President under Article 74 shall not be inquired into any court. This is directly written in the Constitution. This is excluded. Which of them are excluded? Yes, this is excluded from judicial review. Judiciary cannot look into the advice. What advice is tendered by Council of Minister to President? Whatever said by any minister in Parliament, any member in Parliament, ab jaakar you cannot go into court. It is excluded from judicial review. Second, the power of governor to grant pardon and suspend punishment cannot be truncated by any court of India. Directly ये कह रहा है कि power of governor, is it excluded or not? Actually, the power of governor, previously it was excluded, but now it is not. On the basis of merit, judiciary cannot intervene on the basis of merit. तो ये नहीं कह सकती कि यार the merit of the case is not correct. So that's why we are seeing that this is not according to the law. It can look into procedure or arbitrariness, that the decision taken by governor or president is arbitrary. On the basis of this, it can be reviewed. On the basis of merit, it cannot be reviewed. So is it excluded? No, it is not excluded. It will not come in our answer. One will come, two will not come. This means this is eliminated and this one is also eliminated. Presently, status of money bill is beyond the power of judicial review in India. Ye word, this word, presently. Article 110 clearly says that the whatever speaker decision taken by speaker is the final. So presently it is the status. In Puttaswamy case also and in Aadhaar case also, Supreme Court they touched that topic, but they did not give explicit judgment that the speaker, the decision of speaker is under judicial review. So presently it is excluded. Okay? Presently it is excluded. So answer will be C, 1 and 3 only. Okay? That's it with today's session. We'll see in next lecture. Till then, keep studying. Happy studies. Keep revising. Thank you. Thank you so much.